Today we will talk about a case, A. Lakshmanaswami versus LIC. Now this is a 1963 Supreme Court case. The reason why this case is important is because for the first time the Supreme Court laid down the law, or rather penned down what was dictated in Ashbury Railway Carriage and Iron Company Limited versus Riche. Now, what does this case law, the English case law, state? It states that an action outside the memorandum is ultra vires the company. Ultra vires means beyond, ultra is beyond and vires means power. So, Ashbury Railway Carriage first laid down the principle that if it is not contained in the memorandum, then it is beyond the powers of the company. The equivalent Indian case was this one, A. Lakshmanaswami versus LIC, the 1963 Supreme Court case. We will first go through a brief structure of this case. We will look at the head note, which talks about what judgment was laid down by this particular case, and then we will look in detail about the facts of the case and the judgment arrived at. We look at a summary of the case. On 15 July 1955, at an extraordinary general meeting of the shareholders of United India Assurance Life Assurance Company Limited, a resolution was passed, among other matters, sanctioning a donation of rupees 2 lakhs from out of the shareholders' dividend account to a trust proposed to be formed with the object, among other things, of promoting technical or business knowledge, including knowledge in insurance. Now, on 1st July 1956, the Life Insurance Corporation Act came into force, by the provisions of which, on the appointed day, all the assets and liabilities appertaining to the controlled business of the insurer vested in the Life Insurance Corporation. Now, by Section 15(1) subsection A of the Life Insurance Corporation Act, power was given to the corporation to apply to the tribunal for relief in respect of payments made by the insurers during the 5 years preceding the date of vesting, not reasonably necessary for the purpose of the controlled business. The corporation applied to the tribunal for relief in respect of the payments of rupees 2 lakhs by the company to the appellants on the ground that the said payment was ultra vires the power of the company and was not reasonably necessary for the purpose of the controlled business. The tribunal ordered the appellants to restore the sum of rupees 2 lakhs to the corporation, and therefore, on appeal by special leave, the case was heard by the Supreme Court. Now, the Supreme Court held a lot of things in this particular case. The first being that the shareholders' dividend account provided for by the articles did not confer any proprietary interest to the shareholders, though it was charged for the purpose of paying dividends to the shareholders, and that the mere description of the dividend account as the exclusive property of shareholders did not thereby create a proprietary interest in the shareholders. So, while the shareholders' dividend account was meant for the shareholders, it did not confer any proprietary interest on the shareholders. The right to dividend depends upon the recommendation to be made by the directors, without which the shareholders acquire no right, absolutely no right, to the fund or any part thereof. The second thing that the Supreme Court held was that the meeting in which the resolution was passed was a meeting of the company, and it could not be contended that it was a meeting of the shareholders in their individual capacity. The Supreme Court also held that the resolution of the company and the acceptance by the appellants of the amount did not, I repeat, did not constitute a contract, there being no consideration to support it. held further that the object of the company, that is to invest and deal with funds and assets of the company upon such securities or investments, could not authorize the making of the donation, and such a power was not expressly provided for by the memorandum, could not be found by reference to the general clause of the memorandum giving power to do incidental things. So neither was this donation provided for by the memorandum, nor could a reference be made to the general clause of the memorandum giving power to do incidental things. It was further held that the resort to the Articles of Association for the purpose of construing the memorandum was permissible only on matters regarding which the memorandum was silent or ambiguous. So where the memorandum was silent or ambiguous, you could look at the Articles of Association and thereby draw a conclusion. Held further that the making of donations to the trusts which may or may not provide indirect or remote benefits to the business of insurance was not within the power of the company. Held also that the action of the company being ultra vires, it created no legal effect and could not be ratified even if all the shareholders agreed, and payments made pursuant to such action created no rights in the appellants, and they were rightly directed under Section 15 of the Life Insurance Corporation Act to personally refund the amount. So even if you got shareholder approval, if it was not there in the memorandum of association of the company, it is ultra vires the company. And therefore, the appellants were held personally liable. They had to personally refund the amount under Section 15 of the Life Insurance Corporation Act. Now we go to the judgment. We look first at the facts of the case in detail. Now, the United India Life Assurance Company Limited, hereinafter called the company, incorporated under the Indian Companies Act 1882 with the principal object of carrying on life insurance business in all its branches, was registered as an insurer under the Life Insurance Corporation Act, that is 6 of 1938, for carrying on life insurance business in India. Now, on 15 July 1955, an extraordinary general meeting of the shareholders of the company, the following resolution amongst others was passed. What was the resolution which was passed? Resolved that a donation of rupees 2 lakhs be sanctioned from out of the shareholders' dividend fund to the M.C.T.M. Chidambaram Chettiar Memorial Trust, proposed to be formed with the object, among other things, of promoting technical or business knowledge, including the knowledge in insurance. Resolved further that the directors be and are hereby authorized to pay the aforesaid sum to the trustees of the aforesaid trust when it is formed. Now, on the date of this resolution, appellants 2 and 4 were the directors of the company, appellant 4 being the chairman of the board of directors. Now, on 6 December 1955, 5 settlers, including the company, executed a deed reciting that the settlers desire to establish a charitable trust for commemorating the name of the late M.C.T.M. Chidambaram Chettiar, befitting his services to various institutions and organizations with which he was connected, and to industry, commerce, finance, art and science in general, and the great encouragement he gave to education, training, research and promotion of human relationship. And with that object, the settlers had declared, transferred and delivered to the trustees a sum of rupees 25,000 and interest, rents, dividends, profits and other income thereof to be held upon trust for the objects and purposes mentioned in the deed. Now, you need to know something that is that appellants 2 and 4 were directors of the company, 4 being the chairman of the board of directors. Now, what were the objects of this trust, the Chettiar Trust? The objects of the trust were manifold. Example, to establish and maintain scholarships, stipends, allowances to be awarded to Indian students for prosecuting studies, to provide chairs or lectureships, to conduct competitions, to test proficiency in the art of essay writing or speaking, to promote art, science, industrial, technical or business knowledge, including the knowledge of banking, insurance, commerce and industry. Now this part is highlighted because this deals with the business of LIC, and that is insurance. So one of the objects of the trust again were to promote art, science, industrial, technical or business knowledge, including the knowledge of banking, insurance, commerce and industry. Now, to establish and maintain subsidies or support charities in India engaged in improving human relations in industrial and commercial affairs, to establish and maintain or support any educational institution or libraries in India for imparting general, technical or scientific knowledge, and to give subscriptions or donations or to render financial assistance to any educational or other charitable institution in India. Now, appellants 2, 3 and 4 were the trustees nominated under the deed of trust. And the first appellant was appointed a trustee under clause 8 of the deed. Remember, appellant 4 was the chairman of the company, of the board of directors of the company. And out here, he's a trustee under the deed of trust for the Chettiar Trust. Now, in pursuance of the resolution dated 15 July 1955, the directors of the company made an initial installment of rupees 5,000 to the trustees, and the balance of rupees 1,95,000 was paid on 15 December 1955. Now, fast forward to the 1st of July 1956. The Life Insurance Corporation Act 1956 was brought into force. Under Section 7 of this Life Insurance Corporation Act, on the appointed day, all assets and liabilities appertaining to the controlled business of all insurers were to stand transferred to and vested in the Life Insurance Corporation of India. The expression control business meant, amongst others, in the case of any insurer specified in subclause A2 of subclause B of clause 9 of section 2 of the Insurance Act, and carrying on insurance business, all his business if he carries on no other class of insurance business. Now, September 1, 1956 was notified as the appointed day, and on that day, all the assets and liabilities of the insurers, including the companies, were transferred to and vested in the Life Insurance Corporation. On 30th September 1957, the Life Insurance Corporation, which will hereinafter be referred to as a corporation, called upon the appellants to refund the amount of rupees 2 lakhs received by the trust from the company in December 1955. And the appellants, by their letter dated 10th December 1957, having denied liability to refund the amount, the corporation on 14 March 1958 applied to the Life Insurance Tribunal constituted under the Life Insurance Corporation Act for an order that the trustees be ordered jointly and severally to pay to the corporation the sum of rupees 2 lakhs with interest thereon at the rate of 6% per annum from the date of payment to the trustees. Okay, so basically, what if I had to put this in a nutshell, it would be that in 1955, 2 lakhs was received by the trust. 1956, the LIC Act was formed. 30th September 1957, the corporation asked the appellants to refund 2 lakhs received from the company. On 10 December, the appellants denied, 10 December 1957, the appellants denied having any liability to refund the amount. And therefore, on 14th March 1958, the company went to the Life Insurance Tribunal and asked for directions to make the trustees jointly and severally responsible to pay the corporation rupees 2 lakhs plus interest thereon. Now, it was alleged by the corporation, now we're looking at the case of the corporation, that the resolution dated July 15, 1955, as well as the payments made in pursuance of that resolution were ultra vires the company and void and had no effect in law. That the memorandum of the company did not authorize such payment, that making of such donation was not in the interest of the company's business, nor was it generally recognized method of conducting the business, and by the donation no direct or substantial advantage accrued to the company. So the company makes a case that this donation is ultra vires the company. It does not really help the company in its business. Now let's look at what the appellant said. The appellants by the written statement submitted that the directors of the company were authorized by the Articles of Association of the company to make donations towards any charitable trust or benevolent object or for any public, general or useful object. That the amount of rupees 2 lakhs was paid out of the shareholders' dividend account, which was distinct and separate from the general assets of the company, and under the Articles of Association, money standing to the credit of the shareholders' dividend account, being the exclusive property of the shareholders and not of the company, was held by the company for and on behalf of the shareholders and in trust for them. That the shareholders had absolute right of disposal over the said account, and the shareholders of the company having resolved to donate rupees 2 lakhs to the trust out of the account in exercise of their absolute ownership and power of disposal over the said fund, the payment could not be called into question by the company or by anybody purporting to act on behalf of the company, for if the company had not taken over by the corporation, the impugned payment could not have been challenged as ultra vires, and the powers of the corporation were not larger in scope and ambit than that of the company. The appellants also contended that the trustees were not personally liable to refund the amount claimed. Now, on 20th December 1958, the Life Insurance Tribunal ruled, and the tribunal directed the appellants to pay jointly and severally rupees 2 lakhs within 15 days from the date of service of the order, and in default to pay interest thereon at the rate of 6% per annum till the date of realization. And of course, the appellants therefore had to appeal this order in the Supreme Court. The right of the corporation to demand payment of the amount if the resolution sanctioning payment was unauthorized cannot be challenged in view of the express provision in Section 15 of the Life Insurance Corporation Act. Now, what does this Section 15 say? Under Section 15(1)(a) of the Life Insurance Corporation Act 1956, where an insurer whose controlled business has been transferred to and vested in a corporation under the Act has at any time within the 5 years before the 19th day of January 1956 made any payment to any person without consideration, the payment not being reasonably necessary for the purpose of the controlled business of the insurer, or has been made with an unreasonable lack of prudence on the part of the insurer, regard being had that in either case to the circumstances at that time, the corporation may apply for relief to the tribunal in respect of such transaction, and by clause 2, the tribunal is authorized to make such order against any of the parties to the application as it thinks just, having regard to the extent to which those parties were respectively responsible for the transaction or benefited from it and all the circumstances of the case. Now, it is necessary in the first instance to ascertain the true effect of the resolution dated 15 July 1955 and the character of the shareholders' dividend account. Now, this is where the court is coming to a conclusion. So, therefore, they say that they need to first ascertain the true effect of the resolution dated 15 July 1955 and the character of the shareholders' dividend account. Because remember, the company said that the shareholders' dividend account is not belonging to the company but belongs to the shareholders, and since the shareholders have given their okay to give this donation, the company has no say in the matter and therefore cannot say that this donation is ultra vires the company. Now, the material clauses of the Article of Association of the company relating to the constitution of the shareholders' dividend account are Articles 116 and 117. Article 116 reads, interest on the paid up capital at the rate of 6% per annum simple for each of the years covered by the valuation period shall from a first charge on and be deducted from the surplus remaining, and the said amount shall become the exclusive property of the shareholders and shall be carried over to the shareholders' dividend account. Again, 116 reads as interest on the paid up capital at the rate of 6% per annum simple interest for each of the years covered by the valuation period shall from a first charge on and be deducted from the surplus remaining, and the said amount shall become the exclusive property of the shareholders and shall be carried over to the shareholders' dividend account. That's 116. Article 117 reads, of the remaining surplus, the shareholder shall be entitled to a 1/10th share, and the remaining representing the said 1/10th share shall also henceforth become the exclusive property of the shareholders and be carried over to the shareholders' dividend account. Article 119 provides for the payment of dividend and or bonus out of the shareholders' dividend account. The article states that dividend and or bonus shall be declared and paid to the shareholders in proportion to the paid up capital from and out of the total amount remaining in the shareholders' dividend account in accordance with the provisions of the article. Now, Article 123 provided that no larger dividend shall be declared than is recommended by the directors, but the company in a general meeting may declare a smaller dividend. Article 124 states that no dividend is payable to the shareholders except out of the surplus of the company, and such dividend shall not be paid except from the amount in the shareholders' dividend account. So these are the relevant articles. Now, by the resolution passed by the company on 15 July 1955, it was resolved that to donate rupees 2 lakhs to the trust. Undoubtedly, the amount was payable out of the shareholders' dividend account. But by the impugned resolution, no dividend was declared. Now, every resolution of the company directing payment out of the shareholders' dividend account is not a resolution declaring dividend. The directors have to recommend payment of dividend at a certain rate, and a resolution declaring dividend so recommended or at a smaller rate may alone be passed. The directors had at the same meeting recommended payment of interim dividend, that is free from income tax, at the rate of ₹50 per share on the paid up capital of the company, and it was resolved that the dividend at the rate be paid out of the shareholders' dividend account in respect of all shares to such persons as were registered as holders of the shares. Now, the impugned resolution was therefore 1. Donating an amount to the trust, and 2. Not declaring dividend payable on behalf of the shareholders to the trust. Constitution of a separate shareholders' dividend account in life insurance companies was necessitated because Section 49 of the Insurance Act 1938. Please look at Section 49 of the Insurance Act 1938. Prohibited insurers of certain classes, and the company is an insurer of that class, from carrying on business of life insurance, from utilizing directly or indirectly any portion of the life insurance fund or of the fund of such other class or subclass of insurance business as the case may be, for the purpose of declaring or paying any dividend to shareholders or any bonus to policyholders or making any payment in service of any debentures, except a surplus shown in the valuation balance sheet in Form 1 as set forth in the fourth schedule submitted to the controller as part of the abstract referred to in Section 15 as a result of an actual valuation of the assets and liabilities of the insurer. Now, by Section 10(1), every insurer carrying on life insurance business was required to maintain a separate fund of receipts due in respect of such business, a separate fund distinct from all other assets of the insurer, and deposits made by the insurer in respect of life insurance business were to be deemed parts of the assets of such fund. By subsection 3 of the life insurance fund was made absolute the security of life insurance policyholders and could not be applied directly or indirectly for purposes other than those of life insurance business. Now, by Section 13, Every such insurer was required to cause an investigation to be made in respect of all life insurance business transacted by him once in 3 years by an actuary into the financial condition of the business, including a valuation in respect thereof, and to cause an abstract of the report of such actuary to be made in accordance with the regulations contained in Part 1 of the 4th schedule and in conformity with the requirements of Part 2 of that schedule. Now, by the 4th schedule in Part 1, various regulations for the preparation of abstracts of actuaries' reports are laid down, and Part 2 prescribes requirements applicable to an abstract in respect of life insurance business. To maintain a reserve account for payment of dividends, Articles 116 and 117 provide that out of the surplus shown in the valuation balance sheet, interest on the paid up capital at the rate of 6% per annum for each of the years covered by the valuation period, and of a 10% share of the remaining surplus shall be set apart and be carried over to the shareholders' dividend account. So this is what the shareholders' dividend account was, basically how the funds came into the account. Interest on the paid up capital at the rate of 6% per annum for each of the years covered by the valuation period, and of a 10% share of the remaining surplus shall be set apart and sent to the shareholders' dividend account. Now, the scheme of the two articles is that the surplus is to be allocated first to the shareholders for the percentages prescribed and then to the policy holders. And by Article 124, dividend is to be made payable only out of the surplus which is included in the shareholders' dividend account. Now, by Articles 116 and 117, the amounts so set apart are declared to be the executive property of the shareholders, that however do not create in the individual shareholders and proprietary interest in the shareholders' dividend account. Until dividend is declared, the shareholders have no right to participate in the fund. The expression exclusive property of the shareholders only emphasizes that in the shareholders' dividend account, the policy holders have no interest. It means that the fund is divisible only among shareholders. Policyholders have no right to participate therein. However, unit dividend is declared, the shareholders do not become the creditors of the company for a fractional share in the fund proportionate to the value of their holding, as observed by this court in Bacha F. Guzdar versus Commissioner of Income Tax, Bombay. The true position of a shareholder is that on buying of shares, an investor becomes entitled to participate in the profits of the company in which he holds the shares, if and when the company declares, subject to the Articles of Association, that the profits or any portion thereof should be distributed by way of dividends among the shareholders. He has undoubtedly a further right to participate in the assets of the company, which would be left over after winding up, but not in the assets as a whole. So this was the decision in Bacha F. Guzdar versus Commissioner of Income Tax, that the true position of a shareholder is that on buying of shares, an investor becomes entitled to participate in the profits of the company in which he holds the shares, if and when the company declares, subject to the Articles of Association, that the profits or any portion thereof should be distributed by way of dividend among the shareholders. He has undoubtedly a further right to participate in the assets of the company which would be left over after winding up, but not in the assets as a whole. The fund therefore belongs to the company and continues to belong until its destination is determined by a resolution of the company declaring a dividend pursuant to the recommendation of the directors. Now, the scheme of Articles of Association of the company makes this abundantly clear. The power to declare a dividend is given by Articles 122 and 123 to the company in the general meeting, but no larger dividend can be declared than what is recommended by the directors. The right to dividend therefore depends upon the recommendation to be made by the directors, and unless there is a recommendation made by the directors and the general meeting declares a dividend, the shareholders acquire no right to the fund or any part thereof, out of which dividend is when declared payable. Now, the argument of counsel for the appellants that the meeting held on 15th July 1955 was a meeting of shareholders, and when the shareholders resolved to donate an amount of rupees 2 lakhs out of the shareholders' dividend account, they must be deemed to have resolved upon the destination of a part of the fund to which they were entitled, has therefore no force. The meeting was a meeting of the company specifically convened for considering various resolutions, one of which was to make a donation of rupees 2 lakhs out of the shareholders' dividend account. Dividend is by the articles undoubtedly payable out of the shareholders' dividend account, but until a resolution is passed by the company in a general meeting, no part of that account belongs to the shareholders as dividend. It is common ground that no resolution was passed declaring that the amount of rupees 2 lakhs be declared as dividend and paid over to the shareholders. Now, the contention raised by the counsel for the appellants that the resolution of the company and the acceptance thereof by the appellants as trustees of the trust constituted a contract, in our judgment, is future. Now this argument the Supreme Court did not accept. And why did they not accept? What was it? That the resolution of the company and the acceptance thereof by the appellants as trustees of the trust constituted a contract. Supreme Court said no. Why? Here. There was within the meaning of the Indian Contract Act no consideration moving from trustees for accepting the amount, assuming that the resolution amounted to an offer. By section 2 clause D of the Indian Contract Act, when at the desire of the promisor, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or abstain from doing something, such act or abstinence or promise is called a consideration for the promise. Now, mere willingness to utilize monies for the purpose of the trust cannot be regarded as consideration. For consideration to support an agreement must be valuable. Now, this is the opinion of the Supreme Court. Now, in the case before us, even before the trust came into existence, the directors of the company entertained a desire to make a donation in favor of the trust to be constituted, and a resolution of the company sanctioning the donation was passed. Now, when the trust deed was executed by the directors, paid over the amount pursuant to the resolution to the trust. By mere acceptance of the amount donated, no consideration was rendered by the trust in favor of the company. Payment by the company of the amount resolved to be donated was therefore purely gratuitous. Its acceptance made it a gift and did not give rise to a contract. A company is competent to carry out its objects specified in the Memorandum of Association and cannot travel beyond the objects. Now, the objects of the company are set out in clause 3. By the first subclause, the company is authorized to carry on life insurance business in all its branches and all kinds of indemnity and guarantee business, and for that purpose to enter into and carry into effect all contracts and arrangements. By subclause 2, the company is authorized to invest and deal with funds and assets of the company upon such securities or investments, and in such manner as may from time to time be fixed by the Articles of Association of the company. Subclauses 3 and 4 are not material for the purpose of this appeal. Now, by sub 5, the company is authorized to do all such other things that are incidental or conducive to the attainment of the above objects or any of them. The Memorandum of Association must, like any other document, be construed according to accepted principles applicable to the interpretation of all legal documents, and no rigid canon of construction is to be applied to such document. Like any other document, it must be read fairly and its import derived from a reasonable interpretation of the language which it employs. This was held in Egyptian Salt and Soda Company versus Port Said Salt Association. As observed in Ashbury Railway Carriages and Iron Company versus Riche, the covenant, therefore, is not merely that every member will observe the conditions upon which the company is established, but that no change shall be made in those conditions, and if there is a covenant, that no change shall be made in the objects for which the company is established. I apprehend that That includes within it the engagement that no object shall be pursued by the company or attempted to be attained by the company in practice except an object which is mentioned in the Memorandum of Association. Now this was held in Ashbury Railway Carriage versus and Iron Company versus Riche. Now my lords, if it is so, if that is the condition upon which the corporation is established, it is a mode of incorporation which contains in it both that which is affirmative and that which is negative. It states affirmatively the ambit and extent of vitality and power by which by law are given to the corporation, and it states, if it is necessary so to state, negatively that nothing shall be done beyond that ambit, and that no attempt shall be made to use the corporate life for any other purpose than that which is so specified. Now, power to carry out an object undoubtedly includes power to carry out what is incidental or conducive to the attainment of that object. For such extension merely permits something to be done which is connected with the objects to be attained, as being naturally conducive thereto. Now, by subclauses 1 of clause 3 of the objects clause of the Memorandum of Association, the company is to carry on life insurance business in all its branches. Clause 2 authorizes the company to invest and deal with funds and assets of the company upon such securities and investments and in such manner as may from time to time be fixed by the Articles of Association of the company. This is in truth not an object clause, it is a clause authorizing investment of funds. Clause 2 does not invest the directors with the power to deal with the funds in such a manner as may from time to time be fixed by the articles of power. Power conferred thereby is power to invest and deal with funds and assets of the company. The directors under subclause 2 of clause 3 merely have the power to invest and deal with the funds and the assets of the company upon such securities or investments, and the power is to be exercised in a manner prescribed by the Articles of Association. Article 93T. The directors are undoubtedly invested with authority to establish, maintain and subscribe to any institution or society which may be for the benefit of the company, and to make payments towards any charitable or any benevolent object or for any general public, general or useful object. But this is within the authority of the directors only if the company has the power under the Memorandum of Association to achieve the object specified, or for doing anything incidental to or naturally conducive to the object specified. If the object is not within the competence of the company, the directors relying upon Article 93T cannot expend the funds of the company for achieving that object. The primary objective of the company is to carry on life insurance business in all its branches, and the donations of the company's funds for the benefit of a trust for the charitable purpose is not incidental to or naturally conducive to that object. There is in fact no discernible connection between the donation and the objects of the company. Undoubtedly, the Memorandum of Association has to be read together with the Articles of Association where the terms are ambiguous or silent. Now, as observed in Angostura Bitters and Company Limited versus Care by the Judicial Committee of the Privy Council, that except in respect of such matters as must by statute be provided for by the memorandum, it is not to be regarded as the dominant document, but is to be read in conjunction with the articles. This was held in Harrison versus Mexican Railway Company, Anderson's case, Guinness versus Land Corporation of Ireland, and in the matter of South Durham Brewery Company. Their lordships agree that in such cases the two documents must be read together at all events so far as may be necessary to explain any ambiguity appearing in the terms in the memorandum or to supplement it upon any matter as to which it is silent. There is, however, no ambiguity in the relevant terms of the memorandum of association. Clause 3 of the memorandum deals with the objects and the powers of the company in the language which is reasonably plain. The articles may explain the memorandum but cannot extend its scope. Subclause 5 merely authorizes a company to do all such other things as are incidental or conducive to the attainment of the above objects or any of them. The clause merely sets out what is implicit in the interpretation of every memorandum of association. It does not set up any independent object and confers no additional power. Acts incidental to or naturally conducive to the main object are those which have a reasonably proximate connection with the object, and some indirect or remote benefit which the company may obtain by doing an act not otherwise within the object laws will not be permitted by this extension. Now, in Tompkinson versus the South Eastern Railway, it was held that a resolution passed with the shareholders of a railway company authorizing the directors to subscribe £1,000 out of the company's funds towards a donation to the Imperial Institute was ultra vires, even though the establishment of the institute would benefit the company by causing an increase in passenger traffic over their line. Justice K, announcing the judgment of the court, observed. Now, what is proposed to be done here is this. The chairman of the railway company at a meeting of the company proposed this resolution that the directors be authorized either by way of donation from the company or by an appeal to the proprietors as they may be advised. The resolution thus proposing two alternative modes: to subscribe the sum of £1,000 to the Imperial Institute. I pause there. The Imperial Institute has no connection with this railway company than the present exhibition of pictures at Burlington House, of Grosvenor Gallery or Madame Tussauds, or any other institution in London that can be mentioned. The only ground for the suggestion that this company has the right to apply its funds, which it has been allowed to raise for specific purpose, to this purpose is that the Imperial Institute, if it succeeds, will very probably greatly increase traffic of this company. If that is a good reason, then, as I pointed out during the argument, any possible kind of exhibition which, by being established in London, would probably increase the traffic of the railway company by inducing people to come up to see it, would be an object to which a railway company might subscribe part of its funds. I never heard of such a rule, and as far as I understand the law, that clearly would not be a proper application of the monies of the railway company. I cannot distinguish this case from that at all, though of course I do not mean to disparage the enormous importance of the Imperial Institute. It may be established for the highest possible objects of interest to this country. But still, the only reason given to me why this railway company thinks it right to spend part of its funds in subscribing to it is this: that it will probably greatly increase the traffic of the company by inducing many people to travel up to visit this institute. I cannot accept this as a reason for a moment. The trust has numerous objects, one of which is undoubtedly to promote art, science, industrial, technical, or business knowledge, including the knowledge in banking, insurance, commerce, and industry. There is no obligation upon the trustee to utilize a fund or any part thereof for promoting education insurance, and even if the trustee utilized the fund for that purpose, it was problematic whether any such person trained in insurance business and practice were likely to take up employment with the company. Thus, the ultimate benefit which may result to the company from the availability of personnel trained in insurance, if the trust utilizes the fund for promoting education, insurance, practice, and business, is too indirect to be regarded as incidental or naturally conducive to the object of the company. We are, therefore, of the view that the resolution donating funds of the company was not within the objects mentioned in the memorandum, and on that account it was ultra vires. So it is out here that the Supreme Court concludes that the resolution donating the funds of the company was not within the objects mentioned in the memorandum of association, and therefore it was ultra vires. Now, where a company does an act which is ultra vires, no legal relationship or effect ensues therefrom. Such an act is absolutely void and cannot be ratified even if all shareholders agree. This was held in the case of Burbank Permanent Benefit Building Society. The payment made pursuant to the resolution was therefore unauthorized, and the trustees acquired no right to the amount paid by the directors to the trust. Now, the only question which remains to be considered is whether the appellants were personally liable to refund the amount paid to them. Appellants 2 and 4 were at the material time directors of the company, and they took part in the meeting held under the chairmanship of the fourth appellant, in which the resolution which we have held ultra vires was passed. And as office bearers of the company, they who are responsible for the passing of resolution ultra vires the company, they will be personally liable to make good the amount belonging to the company which was unlawfully disbursed in pursuance of the resolution. Again, by Section 15 of the Life Insurance Corporation Act 1956, the Life Insurance Corporation is entitled to demand that any amount paid over to any person without consideration and not reasonably necessary for the purpose of the controlled business of the insurer be ordered to be refunded, and by subsection 2, authority is conferred upon the tribunal to make such order against any of the parties to the application as it thinks just, having regard to the extent to which those parties were respectively responsible for the transaction or benefited from it and all the circumstances of the case. The trustees, as representing the trust, have benefited from the payment. The amount was, it is common ground, not disposed of before the corporation demanded it from the appellants, and if with notice of the infirmity of the resolution, the trustees proceeded to deal with the fund to which the trust was not legitimately entitled, in our judgment, it would be open for the tribunal to direct the trustees personally to repay the amount received by them, and to which they were not lawfully entitled. The Supreme Court therefore concluded that the appeal fails and dismissed with cause. Appeal dismissed. So, the Supreme Court held that if it is not in the Memorandum of Association, it is ultra vires the company. So, it has to be in the Memorandum of Association of the company. They upheld the decision in Ashbury Carriage Company case.